Made by the Pietermaritzburg High Court has declared the Ingonyama Trust's residential lease program unlawful and unconstitutional. The trust controls about 2.8 million hectares of land in KwaZulu-Natal. It's now being ordered to pay back millions of rands received from tenants since 2012. Lead land researcher from the University of Cape Town, Zenande Booi, joins me now to discuss the significance of this ruling. Zenande, very good to have you with us. Tell us more about this ruling. What is your response to it?
We're very excited by this ruling because one of the most important things it does is that it reiterates the fact that the land rights that people hold in terms of customary law, the land rights people hold in terms of the Interim Protection of Land Rights Act and the Upgrading of Land Tenure Rights Act, rights that have been distorted, ignored, and considered not valid property rights for centuries are actually property rights, and that even though that the land is vested in the Ingonyama Trust to hold on behalf of people, the Ingonyama Trust is not the owner of that land. It's actually the people that live on that land and hold rights in terms of various systems. And it confirmed that decisions being made in relation to that land cannot be made without the people that actually hold rights in relation to that land.
Yeah, so tell us more about the customary law and how it's applicable there.
So people that live on land that is vested in the Ingonyama Trust hold land in different types of ways. One of the ways that they hold land is in terms of Zulu customary law. So customary law operates in different ways in different communities. So if you are a part of a community and are able to get access to land in terms of their customary law, in terms of the Constitution, those are valid property rights, and your rights amount to ownership. Another way that people hold rights to land is in the form of PTOs, which is in terms of the upgrading of Land Tenure Rights Act. In terms of that act, those rights can be turned into ownership rights. And then you also have then the Interim Protection of Informal Land Rights Act, which protects the customary law and other sort of informal rights to land held by people in different types of systems and in different ways in which they engage with the land. So, one of the ways that people do hold rights to land on land held by the trust is Zulu customary law. And the Trust Act itself makes it very clear that those rights exist, that those rights are valid property rights, and the holding of the land by the trust is subject to those rights and is not erased, and those rights are not erased by that.
Okay, so it's a massive win, and the wonderful thing is mainly a group of women that's brought this to the court. Tell us a little bit about them and also the fact that they'll be getting millions back.
So, what's important is really that the community co-applicants that we have been working with for so long really came forward and sort of illustrated and sort of spoke about their experiences in being misled and being told about what they were required to do by the trust in a way that wasn't really the case. So we have some really incredible and powerful women, and they were really brave in sort of coming forward and sort of giving their stories and talking about the impact of this policy by the Ingonyama Trust and enforcing people to conclude these leases. There are 7 co-applicants, community co-applicants that were part of this particular case, but the money that's going to have to be sort of returned is a lot of people across various aspects of the province who had paid various fees in terms of applying for the leases, in terms of paying for the rent that they incurred in terms of the leases, that will now be paid back to people that were never supposed to be leaseholders and who were actually owners of the land that they were forced to conclude leases in relation to.
What do you think was behind the Ingonyama Trust thinking when they did this? Obviously, they wanted to get more money in the purse, but how did they think they'd get away with it?
So a lot of the Ingonyama Trust's annual reports in sort of talking about the lease program, a lot of the times they talk about that they don't really get any money from the state, that this was a way in which they could generate more money to be able to operate as the trust. And another issue that they raised is that which is actually really related to one of the other very important aspects of the judgment, is that currently we do not have a law in South Africa that properly recognizes and protects land rights held in terms of customary law and all these other laws that I've sort of been talking about in a way that protects them, recognizes them, and makes sure that people aren't vulnerable to those rights being taken away from them. And that's really because the Department of Rural Development has yet to adopt such a law. So the Ingonyama Trust was saying, well, they see a gap in the law, and this is their attempt at filling that gap, because there is no other recourse that people have to have their rights to land legible in sort of the mainstream and in the mainstream context, for them to be able to get loans, to be able to get access to money for funding if they wanted to farm on their land or if they wanted to build on their land. So, I mean, a lot of where we are right now is as a result of the fact that we don't have a law in place right now. The last attempt that the government made at passing the law, the Communal Land Rights Act, was declared unconstitutional in 2010, and we still don't have another law right now that deals with that. So they felt that they could get away with this because they were like, well, there's a gap in the law. National government isn't doing anything in relation to that gap in the law. People are vulnerable, so we're going to try and help people, but in a way that actually made people even more vulnerable on their land, imposed incredibly onerous terms on people, and required some of the poorest people in South Africa to be paying rent to the Ingonyama Trust that went up and up and up every year.
So I briefly, sorry, excuse me jumping in here, but we'd run out of time. So hopefully this sort of victory will prevent this from happening in other parts of the country. Do you expect the trust to appeal?
We're hoping not. But, I mean, it is their right to appeal, but it is a very important judgment that I think can help the trust itself figure out how best to protect the rights of people that live on the land that they administer, because they do hold this land on behalf of people and they're not the actual owners of the land. So, I mean, this is a good way of them understanding their relationship to the holders of rights in this land and how they can better engage with them and do what they say that they wanted to do, which is to ensure people are protected on their land, but not in a way that further weakens them.
Zenande Booi, very good to talk to you. Thanks for